Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Levon Player 245010. Today is Tuesday, December 17th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Levon Player, inmate number 245010.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Attorney Alfonzo, Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Player.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Player, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officers bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
Thank you. We now will review the charges that the state your parole officers bring against you and the information underlying each charge. Charge 1, program participation. On March 19th, 2024, you were issued a misconduct for drug use. You were instructed to obtain a substance abuse evaluation and to participate in treatment deemed appropriate by the treatment provider. On April 3rd, 2024, you began services with McCall Behavioral Health and were enrolled into IOP. You failed to attend your groups on April 8th, April 17th, and have since failed to attend the program or to contact them. You were subsequently discharged unsuccessfully on April 17th, 2024. Charge 2, residence. On April 16th, 2024, you were placed at a halfway house. Within 20 minutes of arriving at the halfway house, you left the program without permission, and you have failed since to return. You do not have permission to move from your residence. Charge 3, absconder. On April 16th, 2024, you were placed at a halfway house. Within 20 minutes of arriving at the halfway house, you left the program without permission and have failed since to return. Many efforts to reach you by phone, call, and text have gone unanswered. You have failed to contact parole or report to the parole office. Your whereabouts remained unknown. Charge 4, obedience to the law. On July 10th, 2024, you were involved in a physical domestic violence incident with your girlfriend inside a motel where you and her minor child were staying. You pushed her into the bathroom, causing her to hit her head against the bathroom wall. You then slapped her across the right side of the face with your open left hand twice, and then hit her several times after that. You subsequently caused your girlfriend's right cheek jaw to swell, along with bruising to her right shoulder and minor bruises on both of her arms. Search incidental arrest, you were found to be in possession of heroin and crack cocaine. You were arrested and charged by Waterbury Police for breach of peace. Second, assault third, risk of injury to a child, unlawful restraint second, and possession with intent, narcotic substance. On July 10th, 2024, during a strip search of your person at New Haven Correctional Center, you were found to be in possession of 17 8 milligrams of Suboxone strips. Subsequently, you were arrested by Troop 5 for the charge of possession of narcotics. Charge 5, drugs. On March 13th, 2024, you tested positive for cocaine as confirmed by Premier Biotech Labs. You denied use. A misconduct was issued. On March 27th, 2024, you tested positive for cocaine as confirmed by Premier Biotech Labs. You denied use. A misconduct was issued. On April 3rd, 2024, you tested positive for cocaine as confirmed by Premier Biotech Labs. You denied use. A misconduct was issued. On April 3rd, 2024, you tested positive for cocaine as confirmed by McCall Behavioral Health Networks through Quest Diagnostics. Charge 6, no consumption of alcoholic beverages. On April 3rd, 2024, you rendered a urine sample with McCall Behavioral Health Network. The sample return confirmed positive by Quest Diagnostics for alcohol. On April 15th, 2024, you rendered a urine sample with McCall Behavioral Health Network. That sample returned positive by Quest Diagnostics for alcohol. The state has filed the following exhibits. Exhibit A, remand to custody order. Exhibit B, parole conditions. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, Premier Biotech Lab final reports. Exhibit F, misconducts. Exhibit G, McCall Behavioral Health Network discharge summary. Exhibit H, Quest Diagnostics result report. Exhibit I, criminal information summary troop I. And Exhibit J, Waterbury Police report. The state has also filed an addendum to Exhibit C, which states on October 17th, 2024, Mr. Player was found guilty of assault third and was sentenced to 3 months jail. The charges of breach of peace second, risk of injury to child, unlawful restraint second, and possession of narcotics with intent to sell were nollied under docket ending at 813. He was also found guilty of conveying unauthorized items into an institution and was sentenced to 6 months jail. The charge, possession of controlled substance first offense, was nollied under docket ending in 903. Counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
I did.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. Mr. Player, under charge number 1 on the program participation, since you failed to attend groups, looks like a few dates in April, on April 8th and April 17th, and then you were unsuccessfully discharged. Did you attend any of those classes that you were supposed to, or did you just blow them all off?
No, I completed 3, and I was remanded in a halfway house, and I left the halfway house, so I didn't attend any more groups.
Okay, so you did do 3 of the classes, correct?
Yeah, I did 3.
Okay, and after my phone call with you, so during this period of time, March of 2024 and April of 2024, were you still actively using illegal substances, Mr. Player?
Yes, sir.
Okay. And we're not making excuses here for the hearing examiner, but you realize on paper here, within 20 minutes of being placed in the halfway house, you left the facility, correct?
Yes, because I was sick of heroin, and I didn't know I was going to a halfway house. And I left, miss. I was sick, and I left. I went to get a fix, miss.
And I appreciate your honesty, and I know you told me that when I first spoke to you. And I just want to clarify this, Mr. Player. On the charge number 4, under obedience to the law, you were arrested at an incident at a motel on July 10th of 2024, correct?
Yes.
All right. When you were arrested for that incident there, you were never released into the community, correct? You were arrested and you were in custody and then you were remanded by parole, correct?
Yes, sir.
Okay. And the reason why I want to bring that to your attention, that second charge it's the same incident where I don't know if they missed the stuff on him. It's kind of a double whammy. I can see if they released him to community on a non-surety bond and then they picked him back up. I just want to, I know you saw that, but it's the same incident from the same day. I know it looks like 2 different charges, but he did plead in court in the addendum. I do agree with the addendum, but I just think it's important to put on the record. This is from the same incident. He was never out back into the community where he went and grabbed some of the Suboxone strips and put it on his person to bring it into jail. I just want to make sure that's that's clear for the record. And regarding charge 5 and 6, I believe it's based on my client's misconduct. They were all drug related. He was struggling. He admitted he was struggling at the time. But I just, for charge number 4, in obedience to the law charge, I just want to make sure it's clear for the record. They are distinct charges. I agree with that, but it's July 10th. It's the same day that he was arrested in that incident. That's all I have as far as the first part of the hearing. I do want to be heard about his background at the appropriate time.
Thank you. I'll take a moment before I announce my findings. On charge 1, program participation, I make a finding based on state's exhibits B, C, F, and G, as well as today's testimony. On charge 2, residents, I make a finding based on state's exhibits B, C, and F, as well as testimony. On charge 3, absconder, I make a finding based on state's exhibits B, C, and F, as well as testimony. On charge 4, obedience to the law, I make a finding based off of Mr. Player's conviction, as well as state's exhibits B, C, I, and J. Charge 5, drugs, I make a finding based on state's exhibits B, C, and E through H, as well as testimony. And on charge 6, no consumption of alcoholic beverages, I make a finding based on state's exhibits B, C, G, and H. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel.
Yes, on behalf of Mr. Player, my client is 45 years old. He does have 6 children and does have 4 grandchildren. He is in contact and has a positive relationship with all of them. My client was out for approximately a year prior to being remanded. Upon his previous release, he did successfully complete the Community Solutions Halfway House program in Waterbury. And then he was at the Connection Reentry Assisted Housing to reach in Waterbury also. He did have a case manager while he was there. Also, he was previously sponsored by Mr. Ahmad in Waterbury, and then he was at the Connecticut Renaissance Halfway House East in Waterbury. As far as work while he was out, he did have a full-time job at machine operator at Kelly Green Products in Waterbury. He was there for about 6 months, and then unfortunately the building caught on fire. Obviously wasn't able to go back to work there, and he did participate in some side jobs with that building caught on fire. He also at one point did work full-time at Connecticut Solid Doors in Oakville. This was through Steadfast Staffing Solutions in Waterbury, and then also did work full-time in American Plastics in Waterbury. This was also through a temp agency. Did a report to us. He did successfully complete the Explore program at Willow Clinic in Waterbury. Approximately January 2024 is when he completed it. Also did some IOP at Connecticut Renaissance in Waterbury. And as he previously did put on the record, he did do 3 sessions of the IOP at McCall Behavioral Health Network in Waterbury. Since he's been remanded, he does participate for the past 4 months in the Alcoholics Anonymous meetings. And Mr. Player also suffered some medical issues. Received some x-rays and has a brace to some fractures and fragments in his hands and wrists. He would like to be placed in a halfway house in Waterbury. And is interested in studying counseling through CC, ARC, and is amenable to all job opportunities. Unfortunately, that relapse he had is kind of what had him going downhill. But while he was out, he did work. He did attend some of the classes and is in contact with his family. Thank you.
Thank you. So take a moment before I announce my recommendation.
He's been in, I just want to clarify, I'm sorry to interrupt. Since July 10th of 2024 is showing what he was.
Correct. Yep.
Okay.
Mhm. Mr. Player, being that this is your second parole violation, you received a new conviction on this violation, and you continue to use despite being offered treatment, I recommend revoke and reparole on April 10th, 2025, which is an approximate 9-month sanction, which also coincides with your new end of sentence for this conviction that you received. With the following conditions: no consumption of alcohol, domestic violence, no contact with victims SW, LABR, and LD. A general no contact with FA and halfway house placement. Go ahead, Mr. Player.
Miss, that's the only like support I have is LB and the baby. They still in my life. Like, you know, it wasn't a regular domestic violence. It was like she didn't know I was using. She found my drugs. I was drunk. I was fighting her trying to get my drugs back. She's still my support. Like, that's all I really have is her and the baby. They out of town now, trying to, you know, she just started a new job. That's my only support. She's still in my life, you know. And like, that'll be a big one.
Hold on 1 second. I think we might be able to.
So what I'll do, I'm going to continue to have a no contact with the victims. However, I'm going to put without PO's permission. Okay, so that means
You gotta get permission from she's gonna modify it a little bit, Mr. Players. You have no contact without parole officer's permission. Once you get re-paroled, Mr. Player, you gotta work it out with your field parole officer regarding contact. Okay, so without parole officer's permission. So you need to speak to your PO before you have any contact with her. So you understand that?
All right.
So to be clear, so there's no contact with victims SW, and then no contact with LABR and LD without PO's permission. Okay. My findings and recommendation will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 2nd, 2025. So on January 2nd, 2025, the board is going to review your case. The board can lessen what I recommended. They can let my recommended sanction stand, or they can impose a longer sanction than what I recommended, being that you're on special parole to 2033. Now, if the board does decide to exceed the recommendation that I recommended, then another hearing, which is called a supplemental hearing, will take place, and you would receive notice regarding those specific reasons why the board would want to have you serve a longer sanction. Okay, but this does conclude the hearing. Go ahead.
Oh, so it's going to the board, Mr. Players. I indicated to you on January 2nd. You will get something in writing about a week later to tell you if you're getting out on April 10th or not. You understand? All right, good luck to you.
Thank you, miss.
Thank you.
You're welcome.
Thank you. Have a good one.
Thank you. Good morning.
Morning. Bennett,
We
right?
Bennett, yep, starting in about 10 minutes.
All right, I'll have him down shortly.
Thank you.
Thank you.
Morning.
Hey, how you doing? Have a blessed one.
Good morning.
Good morning, good morning.
We're just waiting for your attorney. She's in another hearing right now. And as soon as she gets done, we'll get started.
Okay, no problem. Oh, I left my paper up there, so. Shit. Excuse me, miss.
Yes.
Is there any way that I could run back to my unit and grab my brief statement, or you think that'll probably take too much time up?
Do you know it off? You don't know what you want us to say? Because I don't.
Okay, that's fine. That's fine.
Because I don't know if the seals are going to allow you to come back and forth. I don't know what's happening at the facility right now.
They would, but if it's an inconvenience, it's fine. I'll trust in the process. That's fine. God, these people are gonna smoke me. Oh my God. Hope for the best, expect the worst.
Mr. Bennett, you could run it back and get it as long as the officers are allowing you to go get it. You could go get it.
Okay, thank you so much. I appreciate it.
Yep. Oh, yeah, up to the line. Have you gone back in? Yeah.
Thank you so much.
Mr. Bennett?
Hello.
Hi, we're still waiting for your attorney, so we're gonna get started as soon as she's done.
Okay, no problem.
Morning, Attorney Jones.
Good morning. Is this Mr. Bennett?
Yes.
How you doing?
Good morning. I apologize for the delay. I was stuck in another hearing.
Good one. That's okay.
Theo Winakor, you ready?
I'm available and ready.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Julian Bennett, 403-772. Today is Tuesday, December 17th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Corrigan Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Julian Andrew Bennett, inmate number 403-772.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Bennett.
As well as Parole Officer Winakor.
Officer
This is
Michael Winakor, Hartford District Office, Mental Health Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Bennett and P.O. Winakor, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bring against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to present all relevant testimony and conduct cross-examination. Once the state is finished, your attorney will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, both the state and your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, miss.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, miss.
Yeah. We now will review the charges the state, your parole officers bringing against you, and the information underlying each charge. P.O. Winakor, starting with charge 1, reporting.
On 7/26/24, you failed to report to the Hartford District Office. You were previously instructed to report on this day and were aware of these instructions.
Charge 2, GPS.
On 6/17/24, you failed to properly charge your GPS, resulting in a shutdown of the unit from 2:48 a.m. until 7:42 a.m. This is a violation of your signed GPS agreement. On 6/23/24, you failed to properly charge your GPS, resulting in a shutdown of the unit from 8:31 a.m. until 10:06 p.m. This is a violation of your signed GPS agreement. On 7/27/24, you failed to properly charge your GPS, resulting in a shutdown of the unit from 10:41 p.m. until 7/31/24 at 10:44 p.m. This is a violation of your signed GPS agreement. On 8/6/24 at 7:19, you knowingly cut your GPS monitoring device off your ankle in an attempt to evade parole supervision. This is a violation of your signed GPS agreement.
Charge 3, curfew.
On 5/16/24, you admitted to being at the Madison Motel in East Hartford, Connecticut, well past your curfew as indicated on your signed GPS agreement. On 7/25/24, you violated your curfew by not returning home to your parole-approved residence until 2:48 a.m. You then left again at 2:53 a.m. and stayed out all night. This is a violation of your signed GPS agreement.
Charge 4, program participation.
On 7/29/24, you were unsuccessfully discharged from the Wheeler Clinic Explore Domestic Violence Program due to non-program participation.
Charge 5, residence.
On 7/22/24, you failed to stay at your only parole-approved residence. You admitted to staying at a girlfriend's house in another area of Hartford overnight. On 7/29/24, you signed a PCS misconduct admitting to violating both your curfew and not staying at your parole-approved residence.
Charge 6, absconder.
On 8/6/24 at 7:19 p.m., you cut your GPS monitor device off your ankle in an attempt to evade parole supervision and conceal your location. You also knowingly and purposely stopped communicating with your parole officer, and your whereabouts were unknown.
Charge 7, obedience to the law.
On 8/8/24, Manchester Police Department were dispatched to a residence of a report of a loud verbal altercation. On arrival, a female exited the apartment with a laceration to her arm, and she stated was from a kitchen knife. You were found to be the only other occupant in the apartment. Evidence collected by the Manchester PD indicated that you assaulted the female utilizing a weapon and subsequently attempted to tamper with the weapon. You were arrested and charged with Connecticut General Statute 53A-181, breach of peace in the second degree. Connecticut General Statute 53A-60, assault in the second degree, and Connecticut General Statute 53A-155, tampering with physical evidence. On 8/9/24, you were arraigned at GA-12 Manchester, where judge determined probable cause.
Charge 8, drugs.
On or around 4/15/24, you submitted to a urine analysis that was positive for cocaine. The urine was sent to Premier Biotech Lab, which confirmed the positive cocaine results indicating you recently used.
Charge 9, behavioral management program.
On 7/29/24, you were unsuccessfully discharged from the Wheeler Clinic Domestic Violence Program due to non-program participation.
Charge 10, mental health evaluation and treatment deemed necessary.
On 5/2/24, you reported to the Hartford District Office and admitted to not taking your prescribed mental health medication and felt you did not need them. You also signed a PCS misconduct acknowledging not taking your mental health medication as ordered. On 8/6/24, during a conversation with your parole officer, you again admitted to not taking or ever resuming your mental health medication prescribed by CHR.
The state has filed the following exhibits, starting with Exhibit A.
Connecticut remand to custody. Connecticut signed conditions of parole. Notice of parole violation with rights. Parole violation report. Premier Biotech Lab report. PCS misconduct reports. Allied Universal Electronic Monitoring reports. Allied Universal Position Location signed. Community Renewal Team email from case manager. Judicial Branch Explorer Discharge report, GPS monitoring agreement, Manchester Police Department case incident report, CRT discharge report summary, State of Connecticut Judicial Branch and Criminal Motor Vehicle pending case name summary.
The state has filed an addendum to Exhibit D, which states on November 5th, 2024, Mr. Bennett pled guilty to breach of peace second and was sentenced to 30 days jail. The charges tampering with physical evidence and assault second were dismissed under docket number ending in 332. Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses. At this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. Winakor?
I just would like to make recommendations for Mr. Bennett. Mr. Bennett and I had a pretty good rapport upon being released in the community. But during the past 6 months prior to this violation, Mr. Bennett was provided various opportunities to make his transition in the community successful. He was provided bus passes, grocery vouchers, stipends for over $5,000, CRT scattered site placement, which was rent-free, housing and various employment opportunities. He was also referred to mental health treatment for supports as well as medication management. Mr. Bennett has proven over time that he's failed to take advantage of the many opportunities presented to him, and his propensity to become violent is evident in his history and recent arrest. He has shown an inability or unwillingness to adhere to his parole conditions. Paroles recommend a period of incarceration until his criminal charge is resolved, and then will defer to the Board of Pardons and Parole for an appropriate sanction time. It should also be noted that Mr. Bennett has a significant history of domestic violence, and he finds himself charged again with another episode of intimate partner violence. It is requested that the Board of Pardons and Parole take into consideration when determining an appropriate length of confinement. It's also recommended that he resume his medications or at least the evaluation and assessment, in addition to being placed in a halfway house setting.
Thank you.
I
Anything
believe-
further?
I do not.
It is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. In regards to charge 1, reporting under release direction, we would submit there's insufficient evidence to support this charge. I would just point to Exhibit I, which is a document from CRT, which appears to indicate the instruction to report is coming from a third party to Mr. Bennett and not directly from his parole officer. It seems clear from that message that Mr. Bennett is made aware of this instruction to report at that actual time, which would be the 7/26/24 date. I'd also point out to the fact that my client was on parole supervision for 6 months, and the 7/26/24 date is the only alleged violation of this reporting. So I think the benefit of the doubt could be given to Mr. Bennett that he was not aware of that instruction, which again, I think is clear by Exhibit I, where it's being given to him by a third party. In regards to charge 2 under GPS, I have no comment as to charge 3. In regards to charge 4 under program participation, and I'd also note that those comments would be the same for charge 9 under behavioral management program, as those charges are essentially duplicative. I would just point out that there's no document submitted by Wheeler Clinic to indicate that my client was unsuccessfully discharged. And I would just indicate that that's impossible to challenge the conclusion that my client was unsuccessfully discharged without a document from Wheeler Clinic indicating who unsuccessfully discharged him and on what basis. I understand there's a summary which I would indicate is conclusory in nature without a document submitted by the actual agency that's purported to have unsuccessfully discharged him. In addition to that, my client does maintain that he did not miss he did not have 3 absences, and that of those of the absences that he did have, it was based on the fact that the program itself had actually canceled. So again, we would submit there's insufficient evidence to support that charge, as that would be relative to charge 4 as well as charge 9. No comment as to charge 5. In regards to charge 6, I would just note that there is my client is alleged this event is alleged to have occurred on August 6th. My client was arrested on August 8th. That's less than a 48-hour period. No absconder warrant issued. We would submit there's insufficient evidence to support the charge that he absconded. In regards to charge 7, obedience to the law, my client did have a matter pending in GA-12. That matter was resolved on November 5th, 2024 by way of an Alford plea to the charge of breach of peace in the 2nd degree. He did receive a 30-day sentence to serve. Nollies were noted on the open counts. And that's the only thing I will add to that. My client did feel as though he needed to resolve that matter quickly so that he could be presented here today for this revocation hearing. And that is the reason why he entered into that plea agreement under the Alford Doctrine. Certainly, if the strength of the state's case could have proven an assault second, which is a very serious charge, I suspect that they would have pursued that. But it would be my position here that they could not prove that charge, and that is the basis for why that charge wasn't pursued. In regards to charge 8 under drugs, my client does admit that he used marijuana, that he was not intentionally trying to use cocaine. He's not a cocaine user, and that if his urine tested positive for cocaine, it was an inadvertent as a result of using marijuana. Again, my comments for charge 9 were the same as the comments before for charge 4. Nothing to add in regards to charge 10. Thank you.
Thank you. Pia Winakor, would you like to add anything further before I announce my findings? Pia Winakor?
He's muted. I don't know if he's aware of
Yeah.
that.
I'm sorry, I apologize for that. So one point I'd like to make is for I actually spoke to Mr. Bennett while he was with his case manager to give him the reporting instructions for the following day. So he and I spoke via phone. And the other information I would like to discuss is the evidence J from the Explorer program. He was unsuccessfully discharged, and that is their discharge summary, discharge report.
Anything further?
The only other thing I would like to say is regarding his criminal charge. I can't speak to the Alford doctor, but what I can say is the behavior was still evident that there was some type of incident with his partner in which Mr. Bennett did not take any responsibility. In fact, he indicated that he was sleeping at the time of the incident, despite the weapon or knife being wiped down and a bloody shirt being hidden. So regardless of what happened in that incident, Mr. Bennett was not forthcoming with the officers during the investigation to discuss at all what happened. If he was honest and upfront and forthcoming, he may not have gotten those original charges to begin with.
Counsel?
And if I could just, yes, absolutely. My client has no obligation to speak to law enforcement. In fact, he has the right to remain silent and exercise his right to counsel. So he has no obligation to speak to law enforcement. He did take responsibility because he entered a guilty plea to the charge of breach of peace in the second degree, the only charge that the state believed that they could prove if they went to trial. And it is his right to enter that plea under the Alford doctrine. And again, even though he disputed the facts of the case, he entered into a plea agreement so that he could get here today to have this revocation hearing. Thank you.
And Pia Winakor, anything further?
Nothing further.
Counsel?
No.
Thank you. I'm going to take a moment before I announce my findings. On charge 1, reporting, I make a finding based on State's Exhibits B, D, F, and I. On charge 2, GPS, I make a no finding on part 1, as the state failed to provide sufficient evidence to prove Mr. Bennett's actions meet the charge, elements of this charge. I make a finding on the rest of the parts listed in this charge based on State's Exhibits B, D, F, G, K, and L. On charge 3, curfew, I make a no finding on part 1, as the state failed to provide sufficient evidence to prove Mr. Bennett's actions meet the elements of this charge. A finding was made on the rest of the parts listed in this charge based on State's Exhibits B, D, F, G, and K. On charge 4, program participation, I make a no finding as the state failed to provide sufficient evidence to prove that Mr. Bennett's actions meet the elements of this charge. On charge 5, residence, I make a no finding as if the state failed to provide sufficient evidence to prove that Mr. Bennett's actions meet the elements of this charge. On charge 6, absconder, I make a finding based on State's Exhibits B, D, G, and L. On charge 7, obedience to the law, I make a finding based on Mr. Bennett's conviction, as well as states exhibits B, D, L, and N. On charge 8, drugs, I make a finding based on states exhibits B, D, and F. On charge 9, behavioral management, I make a no finding as the state failed to provide sufficient evidence to prove that Mr. Bennett's actions meet the elements of this charge. And on charge 10, mental health evaluation and treatment deemed necessary, I make a finding based on states exhibits B, D, F, and M. That concludes the fact-finding portion of this hearing. Before I make my recommendation, both the state and your attorney will have an opportunity to speak to your background and history. P.O. Winakor, do you wish to make a statement regarding Mr. Bennett's background and history at this time?
No comments.
Okay. And counsel, you're muted.
Thank you. My client is 30 years of age. He's single. He has no children. He's lived his childhood years throughout the state of Connecticut as a result of being placed with the Department of Children and Families at the age of 5. He completed the 11th grade and does plan to obtain his GED. He does live with mental illness. He was first released to parole supervision on February 9th of 24. He was sponsored to his mother, and then he was placed in a CRT housing program in Hartford. He was in the community for approximately 6 months, and I believe this is his first violation of parole. He was working at the time multiple jobs, including AD USA in Manchester, warehouse job, working at Chef Walt's, a kitchen in Hartford, as well as working at Dax Foundation in East Hartford. He was attending therapy through CHR in Manchester, where he was meeting with a social worker and attending individual therapy bi-weekly. He was also enrolled, as you were aware, in the Explore Domestic Violence program. He's been in the Department of Corrections now, I believe, for approximately 4.5 months. When he is released or re-paroled, he's asking to be placed. He wanted to be placed in the Danbury, Torrington area, but as I indicated to Mr. Bennett, that is part of the Waterbury jurisdiction. So based on that, he's asking to be placed in a halfway house in the Hartford area. And upon successful completion of a halfway house, he's hopeful to return to CRT housing program. He is open to all employment opportunities that would be available to him. He's amenable to all treatment recommendations, including reestablishing clinical outpatient services, as well as completing the Explore Domestic Violence program. We would be asking, based on all the circumstances, that he be re-paroled at the next available date. Again, he's been incarcerated now for approximately 4.5 months. Thank you.
Thank you. P.O. Winakor, nothing further?
Nothing further.
Okay, and counsel, nothing further?
No.
Okay, I'm just a moment before I make my recommendation.
Yes, Mr. Bennett.
Am I allowed to make a brief statement or?
Oh, yes.
Okay. I wrote it. I said I take complete responsibility for my actions and admit that I've made some mistakes. To be very honest, there were multiple times where I felt as though I kept drawing the short stick, and I expressed that to my special parole officer each time and asked him to return me to prison for a restart. But as he explained to me each time, as a decent human being, it is not his job to lock me up, especially if I didn't commit any crimes, and that his job is to keep me in the community and find ways for me to prosper. Things were very hard for me, which is why I requested a restart and lockup. I've had a lot of time to think, and I agree that a halfway house will help me significantly. If you choose to release me back to the community under the supervision of my parole officer in a halfway house, I absolutely see no room for failure. To my understanding, when placed in a halfway house, the main focus is to help obtain all the necessary things I would need in life to be an upstanding member of society. This is the restart that I needed. Granted, it came in a way that I absolutely didn't need it to. However, it's a restart nonetheless. Whatever decision you choose to make, whether it's to release me back under the supervision of my parole officer or to keep me incarcerated and revoke my parole, I accept and I respect, being that both options are a way for me to continue to better myself as well as ready myself for the day that I am ultimately deemed no longer in need of parole supervision. Thank you for allowing me the time and opportunity to make this somewhat brief statement. Keep your head up, stay strong, and have a blessed day.
Thank you so much.
Thank you, Mr. Bennett.
Thank you.
Thanks, Julian.
Thank you.
And P.O. Winakor, since Mr. Bennett made that statement, nothing further before I announce my recommendation?
No, nothing further.
Okay, and council, nothing further?
No, thank you.
Thank you. And Mr. Bennett, being that this is your first parole violation, while in the community, you were out in the community about 6 months, you did receive a number, I think, of about 7 misconducts. You did receive a new conviction. There was a positive drug screen. I recommend revoke and re-parole on February 10th, 2025, which is an approximate 6-month sanction with the following conditions: domestic violence, anger management, halfway house placement, mental health evaluation, and a general no contact with NC without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 2nd, 2025. On that day, the board can either lessen my recommended sanction, let my recommended sanction stand, or they can impose a sanction longer than what I've recommended, being that you're on special parole until 2027. If they choose to exceed my recommendation of the February 10th date, then another hearing will take place, which is called a supplemental hearing, but you will be informed if that's their decision. Regardless of what, you'll be informed of what the board recommend, what their final recommendation is, okay?
Yes,
Any
ma'am.
questions?
No, miss.
All right, so
No
this does
questions.
conclude your revocation hearing. Council?
Thank you.
Okay, thank you. You're all set, Mr. Bennett.
Thank you so
Good
much for
luck.
having me. All right,
Good luck,
thank you.
Julian. Thank you,
All
right.
P.O. Winakor.
All right, take
Thank
care.
you. Good luck, Julie.
All right, thank you, big dog. I'm good, sir. Long morning already, huh? You all done? Yes, sir. You guys are all set, right?
Yes,
Have a good
I'm all
day.
set. Thank you.
Have a good day.
Two six eight one, can you send that 7 down, please?
Good morning. Thank you. Sorry for the wait.
Yeah, it's no problem. Just quick question. Is this the only one you guys are seeing today?
It's only one I have. I'm not sure about the other officer, but this is the only one the only case I have for this morning.
So I don't know if you could help me. I'm trying to get in a hold of whoever is doing the rest of the ones for New Haven. Would you by any chance know?
Yeah,
I would know.
They have a pretty long list of who they're looking for, the individuals that they need to see, and I'm trying to get it in an order that's suitable to them.
Officer Saunders, I do have the docket in front of me, so the other hearing examiner today does have 4 cases with you at New Haven.
So she has about, I see that starting at 11:30. So you guys, she's not gonna start until 11:30. So for my one, it's up to you how you guys want to call them down, but she doesn't start till 11:30.
So maybe you can help me understand that then. Do you guys usually care who you see in order, or is it whoever is down here you guys can see? I'm just trying to make it easier for them.
No, absolutely. So we're pretty flexible, but we try to go in order. So with her docket, if whoever you could get there first, I'm pretty sure she would be okay with.
Okay.
But if we could go in order, we try to, because we have
Okay,
attorneys.
great. Then I'll just go off of what you just said then. Okay, that works. I appreciate your help.
No problem.
And I'm gonna get him down here in just a moment for you
Awesome.
guys.
Thank you.
Okay,
No problem.
no problem.
Good morning, Attorney Famiglietti.
Good morning. Sorry I'm late.
No, we're running behind. No worries.
Oh, okay.
So I'm actually going to go get the interpreter, and we're also waiting for Mr. Mendez.
Oh, you're still doing Mendez. You're still at the 10 o'clock.
Yeah, I'm actually with Attorney Dean right now. Yeah, I'm behind. Yep. I'm
Oh,
on
okay.
Mendez.
I'm sorry. I thought I was late. I apologize.
No worries.
Okay, babe, thank you. Right now, we'll make sure those are have, yep, right there. I'll talk to you when you're done. Thank you.
Hola,
Morning.
buenos días.
What is your name?
Miguel Mendez.
Good morning, Liza Revere. Please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that you will faithfully discharge according to law your duties as an interpreter to the best of your abilities, so help you God, or upon penalty of perjury?
I do.
Thank you. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Miguel Mendez, 343-668. Today is Tuesday, December 17th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center.
Buenos días, soy la oficial Sanders, examinadora de audiencias para la Junta de Indultos y Libertad Condicional de Connecticut. Esta es una audiencia preliminar en referencia a Miguel Mendez, número 343668. Hoy es martes 17 de diciembre del 2024 y esta audiencia está siendo conducida vía video en la Junta de Indultos y Libertad Condicional y el Centro Correccional de New Haven.
Please state your full name and DOC INMATE number for the record.
Por favor, decir su nombre y número de confinado de DOC para el registro.
Miguel Mendez, 343668.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Hi, good morning. Hannah Dean for the record on behalf of Mr. Mendez. Good morning, sir.
Esta es una audiencia pública. Acceso público a esta audiencia está disponible vía transmisión en vivo. También se presentó para el registro abogada Hannah Dean, su defensora, en el día de hoy.
This is a preliminary hearing which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been referred by the Department of Correction for diversion for substance abuse programming and treatment. If by the end of this hearing, I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know that a preliminary hearing is an adversary proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded.
Esta es una audiencia preliminar, la cual tiene tres propósitos bajo la ley de Connecticut. Determinar si hay causa probable para creer que usted cometió un acto que violó las condiciones de su libertad condicional. Determinar si el acto es suficientemente serio que garantiza la revocación de su libertad condicional. Y para determinar si usted debe ser detenido en prisión pendiente a procedimientos adicionales. El Estado, no usted, tiene la responsabilidad de demostrar que hay causa probable para creer que usted violó una o más de las condiciones de su libertad condicional. Si yo no encuentro causa probable, restableceré su libertad condicional, lo que significa liberarlo y colocarlo nuevamente en supervisión de libertad condicional. Si yo encuentro causa probable y determino que el acto es suficientemente serio para justificar una revocación, usted podría ser detenido en prisión pendiente a procedimientos adicionales. Favor notar que usted ha sido referido por el Departamento de Corrección para desviación para tratamiento y programación de abuso de sustancias. Si al final de esta audiencia determino que usted debe permanecer en prisión pendiente a procedimientos adicionales, proveeré información acerca del proceso de desviación. Usted debe saber que una audiencia preliminar es un procedimiento adversarial. Cualquier cosa que usted diga en esta audiencia puede ser usada en su contra. Esta audiencia está siendo grabada.
The testimony of today's hearing will be taken under oath. Mr. Mendez, please raise your right hand.
El testimonio del día de hoy está tomado bajo juramento. Mr. Mendez, favor levantar su mano derecha.
Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or not guilty of perjury?
Usted jura solemnemente y sinceramente afirma, según sea el caso, que la evidencia que usted brinda en relación a este caso será la verdad, toda la verdad y nada más que la verdad, que así lo ayude Dios o bajo penalidad de perjurio.
Lo juro.
Thank you. First, I will review your rights. Then we will review the parole violation charges that the state year parole officers bring against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on available evidence. Do you have any questions about the purpose or procedure before we begin?
Primero leeré sus derechos, luego revisaremos los cargos de la violación de libertad condicional que el Estado, su oficial de libertad condicional, está presentando en su contra. Luego revisaré e identificaré las pruebas presentadas para el registro. La defensa tendrá la oportunidad de abordar el tema de causa probable y la severidad de las alegaciones. Al concluir esta audiencia, anunciaré mis hallazgos, los cuales serán basados en la evidencia presentada. ¿Tiene alguna pregunta sobre el propósito antes de comenzar?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Usted tiene derechos importantes en esta audiencia, los cuales yo revisaré con usted. Usted tiene el derecho a ser representado por un abogado. Tiene el derecho de recibir notificación escrita de los cargos de violación. Tiene el derecho de revisar la evidencia en su contra antes de esta audiencia. Tiene el derecho de someter evidencia para apoyar su caso. En esta audiencia usted tiene el derecho de interrogar testigos voluntarios, como también interrogar testigos adversos. ¿Entiende usted estos derechos?
Sí.
Yes. We now will review the charges of the state bureau of parole officers bring against you and information underlying each charge. Charge 1, drugs. On or about July 13th, 2024, you used cocaine and fentanyl that resulted in an overdose. You were found at 4:35 a.m. unconscious in the stall of the bathroom. You were administered 3 doses of Narcan until you became alert and transported to Yale. You live in ER. On or about July 22nd, 2024, you used cocaine and fentanyl. On or about August 9th, 2024, you used cocaine. On or around November 6th, 2024, you used cocaine and fentanyl. On or around November 15th, 2024, you used cocaine and fentanyl. Charge 2, halfway house placement. On or around July 22nd, 2024, August 9th, 2024, November 6th, 2024, and November 15th, 2024, you violated your signed halfway house agreement. Most specifically, I will not use, possess, sell, transport, or any way have contact with legal drugs or prescription drugs that are not prescribed to me by a licensed physician.
Ahora estaremos revisando los cargos que el Estado, su oficial de libertad condicional, ha presentado en su contra y la información subyacente a cada cargo. En el cargo número 1, condición de drogas, en o alrededor del 13 de julio del 2024, usted usó cocaína y fentanyl, lo cual resultó en una sobredosis. Usted fue encontrado a las 4:35 de la mañana inconsciente en el lavamanos del baño. Usted fue administrado tres dosis de Narcan hasta que se mostró alerta y fue transportado a la sala de emergencias de Jail New Haven. En alrededor del 22 de julio del 2024, usted usó cocaína y fentanyl. En alrededor del 9 de agosto del 2024, usted usó cocaína. En o alrededor del 6 de noviembre del 2024, usted usó cocaína y fentanyl. En o alrededor del 15 de noviembre del 2024, usted usó cocaína y fentanyl. En el cargo número 2, ubicación en Halfway House, en o alrededor del 22 de julio del 2024, 9 de agosto del 2024, 6 de noviembre del 2024 y 15 de noviembre del 2024, usted violó su acuerdo del Halfway House firmado, específicamente donde dice no usaré, poseeré, venderé, transportaré o estaré en contacto de ninguna forma con drogas ilegales o drogas que no me sean retados por un médico licenciado.
The state has filed the following exhibits. Exhibit A, notice of parole violation. Exhibit B, notice of parole rights. Exhibit C, remand into custody. Exhibit D, halfway house agreement. Exhibit E, PCS conditions. Exhibit F, the connection incident report. Exhibit G, hospital discharge report. Exhibit H, voluntary admission. Exhibit I, misconduct. Exhibit J, the connection incident report. Exhibit K, the connection infractional report. Exhibit L, misconduct. Exhibit M, voluntary admission. Exhibit N, the connection incident report. Exhibit O, voluntary admission. Exhibit P, West lab report. Exhibit Q, misconduct report for August 9th, 2024 use. Exhibit R, voluntary admission. Exhibit S, misconduct. Exhibit T, the connection incident report. Exhibit U, the connection infractional report. And Exhibit B, voluntary admission. And then Exhibit W, which I'm going to add as PBR.
El Estado ha presentado las siguientes pruebas premarcadas con propósitos de identificación. Exhibición A, aviso de violación a libertad condicional. Exhibición B, avisos de derecho de persona en libertad condicional. Exhibición C, orden de regreso a custodia. Exhibición D, acuerdo de Halfway House. Exhibición E, condiciones de PCS. Exhibición F, reporte de incidente de Connection. Exhibición G, papeleo de alta del hospital. Exhibición H, admisión voluntaria. Exhibición I, reporte de conducta. Exhibición J, reporte de incidente de Connection. Exhibición K, reporte de infracción de Connection. Exhibición L, reporte de conducta. Exhibición M, admisión voluntaria. Exhibición N, reporte de incidente de Connection. Exhibición O, admisión voluntaria. Exhibición P, reporte de laboratorio de Quest. Exhibición Q, reporte de conducta por uso el 9 de agosto del 2024. Exhibición R, admisión voluntaria. Exhibición S, reporte de conducta. Exhibición T, reporte de incidente de Connection. Exhibición V, reporte de infracción de Connection. Exhibición T, reporte de incidente de Connection. Y exhibición W, reporte de violación a libertad condicional.
Today we have no witnesses, and it is now the fifth opportunity to respond, to make a short statement, and testify with respect to probable cause and the severity of allegations.
Thank you very much. I just wanted to clarify, because I was a little confused from the PBR, is top placement recommended? Yes. Okay, wonderful. Then, since the top placement is being the is being recommended by the client's probation or parole officer, I would concede probable cause for the first portion of the hearing. I would just note that this is an unfortunate situation. Mr. Mendez struggles with addiction, and I think his PO was trying to work with him to get him inpatient somewhere. To no fault of either of theirs, it sounds like he just wasn't able to be taken inpatient, but I know he is wanting the treatment, so I think that this would be a good disposition if this went to the top program. Thank you.
Thank you.
El cliente ha sido referido por su oficial de libertad condicional para ubicación en el proceso, en el programa de TAP. Por lo tanto, concedo causa probable. Es una situación muy desafortunada. Mi cliente tiene dificultad, tiene problemas con la adicción y entiendo que él no tuvo la oportunidad de tomar tratamiento anteriormente, por lo que entiendo que sería beneficioso el tratamiento en TAP.
Charge 1, drugs. I make a finding of probable cause based on case exhibits P through D of W. It's the PVR. And on charge 2, halfway house placement, I make a finding of probable cause based on case exhibits D through W.
El cargo número 1, drogas, hago un hallazgo de causa probable basado en las exhibiciones del Estado E y W. En el cargo número 2, ubicación en halfway house, hago un hallazgo de causa probable en las exhibiciones del Estado D, W.
I find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you wait for your revocation hearing. The Department of Correction has recommended you for diversion from the revocation process for substance abuse programming and treatment, which is a top program. This means that if you wish to participate and I find that you meet certain eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse programs and treatment in a correctional facility. If you successfully complete the programs and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programs and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and apply for diversion?
Yo encuentro que los actos son suficientemente serios, que garantizan una revocación y también he determinado que usted debe permanecer detenido mientras se espera una audiencia de revocación. El Departamento de Corrección le ha recomendado para una desviación del proceso de revocación para programa y tratamiento de abuso de sustancias. Esto significa que si desea participar, solicita y encuentro que cumple con ciertos criterios de elegibilidad, puedo continuar su caso mientras se le brinda la oportunidad de participar en programa de abuso de sustancias y tratamiento en un centro correccional. Si completa con éxito los programas y el tratamiento proporcionado, desestimaré su caso y ordenaré que se restablezca su libertad condicional. Si no completa los programas y el tratamiento proporcionado, la Junta programará y convocará una audiencia de revocación para determinar si violó las condiciones de su libertad condicional. Si es así, el examinador de audiencias hará recomendaciones sobre si su libertad condicional debe ser revocada y qué sanción, si alguna, debe imponerse. La decisión de participar en el programa de desviación es voluntaria, entiende el proceso y desea solicitar.
Sí.
Yes.
With respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. I have reviewed all relevant information and my findings are as follows. I find that you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the date of remand to actual custody. I find that there is evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of parole. And I find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community.
Ahora anunciaré mis hallazgos con respecto a su elegibilidad. He revisado toda la información relevante y mis hallazgos son los siguientes. Encuentro que usted no tiene cargos pendientes por delitos menores o delitos graves. Encuentro que su fecha de salida es más de 60 días laborables a partir de la fecha de la audiencia de hoy. Encuentro que hay evidencia que usted ha identificado necesidad de tratamiento por abuso de sustancias. Encuentro que el abuso de sustancias es considerado razonablemente como un factor motivador en su aparente incumplimiento con los términos y condiciones de su libertad condicional. y encuentro que hay alguna evidencia que usted recibió o fue provisto de una oportunidad para recibir programas o tratamiento para el abuso de sustancias durante su periodo de supervisión bajo libertad condicional en la comunidad.
I have determined that you are eligible for diversion from substance abuse. Before I accept your application for diversion, that you indicate whether you understand the following by answering yes or no.
He determinado que usted es elegible para la desviación para la programación y el tratamiento de abuso de sustancias. Antes de aceptar su solicitud, le voy a pedir que indique si comprende respondiendo a las siguientes preguntas con un sí o no.
I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Entiendo que permaneceré encarcelado mientras reciba programa y tratamiento y que los procedimientos de revocación de libertad condicional pueden retrasarse como resultado.
Sí.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Entiendo que la desestimación de mi caso y el restablecimiento de la supervisión activa de libertad condicional no están garantizados y están condicionados a que complete con éxito la programación y el tratamiento de abuso de sustancias.
Sí.
Yes.
I understand that ultimately the Department of Correction will determine whether I have successfully completed the substance abuse programming and treatment provided.
Entiendo que en última instancia el Departamento de Corrección determinará si he completado con éxito la programación y el tratamiento de abuso de sustancias proporcionado.
Sí.
Yes.
I understand that my participation in this process is completely voluntary.
Entiendo que mi participación en este proceso es completamente voluntaria.
Sí.
Your application for a diversion is granted. You will be placed in a treatment or program by the Department of Correction and diverted from revocation for no more than 60 business days. So this concludes your preliminary hearing.
Su aplicación de desvío ha sido concedida. Usted será puesto en tratamiento o programación por el Departamento de Corrección y desviado de la revocación por no más de 60 días laborables. Esto concluye la audiencia preliminar.
Ok. Sí.
Thank you.
You're welcome.
Take care. Happy holidays.
You too.
You want to get back to Ramos?
Yeah.
Okay. Thank you. You ain't come here all day, Miss Lynn. Okay, all right. Have a good day. Go be safe. All set, guys?
Thank you. We're all set. Thank you.
No problem. Have a good day.
Good morning. I'm so sorry. Thank you for waiting.
No problem.
I-
Is this for Ramos?
Ramos, yes, because Dattilio, we're not moving forward with Zachary Dattilio today.
Right, because he said he got a continuance for 2 weeks.
Yes, correct. So his case is continued. So we only have Mr. Ramos.
All right, I'm gonna go bring him in right now. He's outside.
Thank you so much.
You're welcome. No, that's it.
Attorney Famiglietti?
All right, you can have a seat in the chair.
Good morning, Mr. Ramos.
Good morning.
Good morning, how you guys doing?
Good. Good morning, sir.
Morning. Can you guys see me right?
Yeah, we're good. Just 1 second. I'm gonna get started in just 1 second.
All right.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Angel Ramos, 314600. Today is Tuesday, December 17th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Angel Ramos, 314-600.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit.
This is a preliminary hearing which has 3 purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause, you may be held in prison pending further proceedings. This is an interstate case and coming from Ohio. Therefore, I do not determine if the act is sufficiently serious to warrant revocation. You should know that a preliminary hearing is an adversary proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Ramos, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you.
You're welcome.
First, I will read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. And I will review and identify exhibits filed for the record. Your attorney will have an opportunity to address the issue of probable cause. At the conclusion of this hearing, I will inform you of my findings, which is based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I talked to my lawyer. We good.
Thank you.
You're
You have
welcome.
important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and then examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
I do.
We now will review the charges that the state your officer is bringing against you and the information underlying each charge. Charge 1, absconder. You last reported on February 20th, 2024. Your next report date of March 5th was switched to March 7th, 2024. You provided verification that you were sick on March 5th, 2024 and March 11th, 2024. Your next report date was switched to March 19th, 2024 due to you being sick. You did not show up for your meeting on March 19th, 2024. A misconduct was approved for you for failure to report. You contacted this officer on March 20th, 2024 with a new cell phone number and were directed to report on March 21st, 2024. You did not report on March 21st, 2024. You have not responded to this officer's phone calls and text messages since March 20th, 2024. Another misconduct was approved for failure to report. On March 27th, 2024, A wellness check was conducted at your approved sponsor's residence, and your sponsor stated she has not seen you in a long time and does not know where you are staying. After searching the residence, it appeared you were not staying with your sponsor. On April 1st, 2024, an attempt to locate was approved with remand authorization for your previous sponsor's residence, which is your girlfriend, who resides in New Britain, Connecticut. And on April 4th, 2024, an attempt to locate was executed at the New Britain address, and no one answered the front apartment door or the back apartment door. Parole Community Services staff were unable to gain entry to this residence. You were not found. Your current whereabouts remain unknown at this time. The state has filed the following exhibits. Exhibit A, State of Ohio Department of Rehabilitation and Correction Adult Parole Authority Conditions of Supervision. Exhibit B, State of Connecticut Board of Pardons and Parole Statement of Understanding and Agreement Conditions of Interstate Parole, and Connecticut Department of Correction, Parole, and Community Services Release Directions. Exhibit C, Connecticut Board of Pardon and Parole Remand to Actual Custody Order. Exhibit D, Notice of Parole Violation and Notice of Parolee Rights. Exhibit E, Interstate Violation Report. Exhibit F, GPS Monitoring Agreement, Parole Community Services. Exhibit G, 3 Offender Misconduct Reports. And Exhibit 8, Allied Universal Electronic Monitoring Offender Violation Summary from March 3rd, 2024 to March 5th, 2024. Council, did you receive the Notice of Parole Violation Report, and the other documents that were just marked for identification purposes?
Yes, I have.
Today, we have no witnesses, and it is now the defense opportunity to respond and make a short statement and testify with respect to probable cause. Council?
Yes, for the charges of reporting and GPS, I have no comment as to probable cause standard.
Can I say something? I was doing great. You know, I got sick on COVID. I told my PO I got sick on COVID. Then, well, the only reason, you know, I ain't gonna lie, I got mad because he put me on the bracelet for no reason. You know, I beat my case that I was fighting for. It got dismissed. The reason that he put me on the bracelet is because he said that he wanted to be a YNR because some investigation. My car got stolen. I reported stolen because I had to. It's under my name. Come to find out, you know, and what he put me on that because he's saying that to finish the investigation, he put me on a bracelet. Now you put me on a bracelet when I don't deserve it. I'm doing good. You know, I ain't got no violations. My case got dismissed. You ain't got nothing to put me on the bracelet for. I'm begging you in the office. Hey, bro, this is not fair. You putting this bracelet on me for 3 months with no sanction. You understand what I'm saying? So, you know, that right there, it really started a little, and you know, it made me go in the road because I did you three months of bracelet when I came out. Perfect. I did a whole year working pay stubs. I'm busting, you know, I'm doing what I'm supposed to do. You know, I caught a case that it was wrong accusing. I beat the case. I got out. It gave me back my parole. And then when I come to your office, now you try to give me my bracelet again. Like, wow. Like, come on, you got to find something to give me the bracelet for it. I ain't did nothing. I ain't got nothing on my record. I ain't catch no case, nothing for you to give me this bracelet. And he said, oh, you got to put it on. I said, talk to your supervisor. Your supervisor give you the authorization to give me the bracelet. Oh, no, I'm going to talk to her after I finish this little investigation. I'll talk to her, see what she say. That's not how you go about, you know what I'm saying? And that's what I got to say.
Thank you, sir.
Thank you. Anything else?
Nothing from the defense. Nothing from me, at least.
I share the report. I still share the report. You know, that's, you know, I ain't got nothing for that one.
On charge one absconder, I made the finding of probable cause based on state's exhibits A, B, D, E, G, I, J, and K. This is an interstate case coming from Ohio. Revocation proceedings would not be conducted by CT. Final decision regarding revocation will be determined by Ohio and the interstate unit. So therefore, this does conclude the preliminary hearing.
Did you make a finding as to charge 2?
They only requested for charge 1 for absconder.
Thank you very much.
Yeah. Okay, so
Okay,
Mr. Ramos,
sir.
go ahead.
So, sir, Parole in Connecticut is going to contact Ohio
Okay,
and notify them that this hearing probable cause was found. And then once Ohio decides what they want to do, you'll be notified by mail. Okay, sir?
all right, I
If
understand.
you have any questions, just let me know, okay?
All
Contact
right.
me. Thank you,
Okay,
sir.
I need your number.
Okay.
You gonna be handling the parole hearing right here in
No,
Connecticut, right?
no, I will not.
So
That
give
will
us
be
the
Ohio if they bring you to Ohio. Okay?
Okay.
All right. So ask your counselor to call the Parole Public Defender's Office. You're at Hartford, correct?
Yes.
I'll make a
ACC.
notation to call you at Hartford. Okay, sir?
All right, that's cool.
Take care, sir. Thank you.
You take care, miss.
And thank you.
Have a good day. Yeah, we done. Thank you, sir.
You're welcome, sir.
Zachary Dattilio's case, inmate number 342478, has been continued to January 7th, 2024.
Get it right back to your unit.
Hey, where the commissary? I gotta give that sheet to the commissary. Ready?
Normally just put it in the box.
And then before that, you're gonna get my insurance paper. And we're gonna go ahead to my week, and you're getting that notice. Is there a phone that you can call and keep the video on and phone? I can, you could write in the chat, maybe you could call it on the phone, the video one, but see, the defendant, but also.
Good morning.
Good morning.
Morning, Mr. Fauquet.
Good morning.
Good morning.
Morning, P.O. Bennett.
Good morning.
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Nicholas Fauquet, 391725. Today is Tuesday, December 17, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Nicholas Fauquet, 391725.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Fauquet.
As well as your parole officer, P.O. Bennett.
Good morning, Parole Officer Bethany Benak from the Mental Health Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to uphold the sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Fauquet and P.O. Bennett, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officers bring against you. Then I will review and identify exhibits filed for the record. The state, as well as your attorney, will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, both the state and your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin? Thank you. You have important rights at this hearing, which I now will review with you. You have a right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to call. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges of the state your parole officers bringing against you and the information underlying each charge. Starting with charge 1, program participation.
On 8/9/24, you were negatively discharged from your mental health intensive outpatient group.
Charge 2, halfway house placement.
Okay, on 7/1/24, you made a vulgar and inappropriate gesture toward a case manager at the Eddy Center. This is in violation of the Eddy Center rules that you signed in the resident handbook. On 7/16/24, you took the house phone into your room. This is a violation of the Eddy Center rules, which you acknowledged awareness of by signing the disciplinary report dated 7/16/24. On 7/18/24, you stole the house phone out of the case manager's office. You did not have permission to use the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/18/24, you were caught vaping in your room. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/18/24, you told a case manager to shut your mouth when he asked you to get off the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/19/24, you were unaccountable in the community from 9 a.m. to 2:40 p.m. This is a violation of the Eddy Center rules that you signed in the resident handbook. On
7/22/24, you referred to a female staff member as wifey and had to be told that that was inappropriate multiple times before you stopped. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/25/24, you called a female staff member a black fat bitch multiple times when she asked you to hang up the house phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/27/24, you called a female staff person a bitch and punched the wall several times. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/31/24, you stole the cordless phone from the staff office. You did not have permission to use the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/31/24, you told the Eddy Center program manager that you were going to smack the shit out of her. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 8/6/24, you did not attend your mental health group. Subsequently, you were unaccounted for in the community for 3 hours. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 8/9/24, you stole the house phone and used it without permission. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 8/9/24, you were negatively discharged from your mental health group. On 8/13/24, you punched the wall in the Eddy Center. Oh my goodness, sorry, I'm getting confused. On 8/13/24, you punched the wall in the hallway of the Eddy Center and broke a floor fan and called the staff cocksuckers. This is a violation of the Eddy Center rules that you signed in the resident handbook.
And charge 3, mental health evaluation and treatment deemed necessary.
Yep, on 8/9/24, you were negatively discharged from your mental health intensive outpatient group that you were referred to by Middlesex Memorial Hospital on 7/31/24.
The state's exhibits were marked and identified at the preliminary hearing held on September 10th, 2024. Council, did you receive the notice of parole violation report, and the other documents that were marked for identifications at the preliminary hearing?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Defense has also filed Exhibit 2, offender work performance and program evaluation form, and Exhibit 3, judicial just screenshots of case docket ending in 860. Today we have no witnesses, and at this time the state will have an opportunity to present evidence and speak to any of the evidence submitted.
I think I only have Exhibit 1. Hold on, I'm sorry. No, I have them all. I'm sorry about that. I mean, as far as the charges, they speak for themselves. He has very inappropriate and immature behavior towards staff. When they say no to him, he does the same thing to me. During the transport, I had noted in the parole violation report that he kicked the cage several times, banged his head, and was very distracting, screaming and yelling, which really poses a threat to the public as well as himself. He was bleeding by the time he got to Corrigan. But in the recommendation, I think I just asked for, I asked for a 1-year sanction because he received a 4-month sanction for his violation in October 2023, as well as a 4-month sanction for his violation in 2024. As far as the violation in 2024, the hearing examiner actually did give him a 6-month sanction, but when the board reviewed it, they saw that he was only at the halfway house for a week and then remanded. He was only at the halfway house for a week at that point in time because he was arrested for the same behaviors. That's all I have.
Council?
Thank you. My comments are essentially the same as they were during the preliminary hearing. I can go through them again. However, in regards to charge 2 under halfway house placement, just addressing the paragraph beginning in July 1st, Exhibit F indicates this behavior was dealt with by way of graduated interventions and sanctions. In regards to 7/16, again, Exhibit F, page 2, this conduct was dealt with by way of graduated interventions and sanctions. July 18th of 24, Exhibit F, page 3, that indicates the conduct was addressed by way of graduated interventions and sanctions. Exhibit for 7/18, the second part of that, again, page 4 of Exhibit F, indicates the conduct was addressed. 7/18, part 3 of 7/18 indicates that the conduct was addressed as well. 7/19, we would submit there's insufficient evidence to support this portion of the charge, as Exhibit G, page 1, indicated that staff was unable to confirm with the root program the client was present the client was present at any point. If that if they were unable to confirm that, then it's our position that the state has not met its burden. In regards to 722, Exhibit F, page 6, the conduct was addressed by way of graduated interventions and sanctions. 725, Exhibit F, page 7, the conduct was dealt with by way of graduated interventions and sanctions. 727, I would just note that my client refused to sign the disciplinary report. That's Exhibit F, page 8. 731 is Exhibit F, page 9. It says that the client was the subject of a disciplinary report. The PO did not issue a graduated intervention or sanction. 731, the second portion of that, Exhibit F, page 10, my client denies the allegations, refused to sign the disciplinary report, and that the PO did issue graduated interventions and sanctions. In regards to August 6th of 24, Exhibit F, page 11, my client denies that conduct, refused to sign, and it does indicate graduated interventions and sanctions were listed. In regards to August 9th, Exhibit F, page 12, the client denied the conduct, refused to sign. It does not indicate that any graduated interventions and sanctions were listed. In regards to the August 13th, Exhibit G, the state police called to assess the situation, did not feel as though there was enough evidence to charge my client with any crime, just pointing that out. In regards to charge 3 under mental health treatment, Exhibit J, my client attended 2 appointments, but then it says it missed 3 consecutive appointments and was discharged. I would just note that from the date of referral, which was on 7/31 of 24, to the date of discharge, August 9th of 24, a very short period of time. I think the evidence establishes that my client was having a difficult time, and I would just point out that that's a very short period of time for which for him to comply with that treatment. Nothing further as to the charges.
Thank you. Bennett, anything further before I announce my findings?
Sure. I think we had the same discussion last time, and it was the same findings. The amount of interventions and sanctions that he received, I think, show more in our favor that we really did try very hard to work with him, and he did not amend any of those behaviors or change those. As far as the mental health treatment, he was referred, and it was supposed to be a PHP, so he was supposed to go all 5 days in that week. That's all I have.
Thank you. Counsel?
Just that it's a very short period of time that we're dealing with here. That's all I would point out.
Bennett, anything else before I announce my findings? Okay. And counsel, nothing further?
Nope.
Okay, thank you. Regarding charge 1 program participation, I make a finding based on 6 exhibits B, D, F, I, and J. On charge 2 halfway house placement, a no finding was made on parts 2, 3, 10, 13, 14, and 15 at the preliminary hearing held on September 10th. Being that there was no further information provided today by the state, those no findings will remain for today's hearing. However, I do make a finding on the rest of the parts listed in this charge based on states exhibits B, D, E, F, G, H, and J. On charge 3, mental health evaluation and treatment deemed necessary, I make a finding based on states exhibits B, D, F, I, and J. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney, as well as the state, will have an opportunity to speak to your background and history. Bennett?
I think I already included the background and history that I would consider including before when I talked about the amount of violations and how quickly they happen. That's all I have.
Thank you. Counsel?
Thank you. My client is 31 years of age. He's single. He has no children, though he has a 7-year-old stepchild. He's a high school graduate of Norwich Free Academy. He has no additional education and supports himself in the community by way of receiving disability for a medical condition that he has. He receives his primary support from his fiance, his family, his siblings, and his mother and father. He lives with both mental health as well as substance abuse issues. He was additionally diagnosed with a serious medical condition. That information is contained within Defense Exhibit 1. He was in the community, I believe, for approximately 2.5 months. I apologize. As you're aware, he was re-paroled back into the community on June 18th, I believe. He explained to me that he was having a difficult time with staff at the halfway house. He was feeling threatened. He indicated he reported the issues to the halfway house staff supervisors. However, he felt as though the issues were not being addressed properly. I would point out that he was that regarding the incidents noted in the charges, The state police responded, 3 troopers, in fact, and it did not feel as though any laws were broken, and my client was not arrested as a result of that. On August 1st of 24, my client did begin mental health treatment by way of intensive outpatient treatment at Middlesex Health Pele Center for Mental Health Services in Middletown. He completed 2 sessions, and though Mr. Fauquet is supported by disability, he has actively searched for work. Our office received documentation from Reach that confirmed that my client was applying for jobs weekly, that he had interviews at Applebee's, McDonald's, Cumberland Farms, Dunkin' Donuts. He is asking for the opportunity to be re-paroled back into the community so that he can demonstrate that he does have the ability to abide by parole conditions and be successful in the community. In addition, he also reports volunteering at CCAR and a desire to return to that position. While he's been incarcerated at this point, he's been in custody now for approximately 4 months. He did complete the Voices program, and I would just note that within that completion, it does indicate his attendance and initiative, productivity, attitude, and overall were recorded as excellent. The comments were that Mr. Fauquet always participates in group discussions. He attended every class with a positive attitude. He had great interactions with his peers. He identified coping mechanisms that he'll utilize whenever he feels stressed. Overall, he's on the right path for making positive changes in his life. So I think that that's important to note, that is something that he has accomplished during this time period that he's been incarcerated. Again, by way of employment, he hopes to return to the community and continue to receive disability, though he does hope to have a part-time job, whatever's permitted through his disability. He's been in custody now for approximately 4 months. And I would just note, based on the technical nature of the violation, as well as his underlying medical conditions that likely contributed to his conduct that led to this violation and ultimate remand, we are respectfully requesting that he be re-paroled at the next date. And I would note that my client was served with a violation of probation warrant during the time period that he's been in custody. I believe his parole officer is aware of that as well. We did submit a request for addendum. However, that was not complied with for whatever reason. I think we probably all can make an assumption on that. I did submit that disposition as evidence here, and I'm asking that the hearing examiner take into consideration that he received a 30-day sentence when issuing the sanction, so that when Mr. Fauquet is eligible to be re-paroled, that he's not re-violated again on a matter that we all were aware of during this hearing. So he was violated on his probation. The violation was based solely on the conduct that's listed in this parole violation report. And based on that, he received a 30-day sentence, and I'm asking that that be taken into consideration. It's been filed as evidence. Everyone here is aware of it. So I am asking that it be taken into consideration here. Again, we're asking based on the situation, the totality of the circumstances here, that he be given an opportunity to re-parole at the next date. Thank you.
Thank you. Bennett, anything further?
No, I did not charge him with the criminal violation though, so I don't think we're really going to consider it in this hearing.
Thank you.
I understand that, but it's a violation of probation that was served on him during the pendency of this violation. I think we were all aware of it. We continued the hearing, in fact, so that we could see the disposition of that violation of probation. I did make a request for an addendum. It could have been added. We are all aware that he received a 30-day sentence. I understand that there are supervisors who do not wish that be included so that they can re-violate him. I don't think that's a proper procedure, but I understand that it's a procedure that's in place. I submitted the disposition as evidence. I'm asking that it be considered. I don't see that it would be necessary for Mr. Fauquet to be given a re-parole date only to be re-violated for conduct that we're all aware of right now. Thank you.
Okay, Bennett? Okay, and counsel?
Nothing further. Thank you.
So before I make my recommendation, I would like to make all parties aware that while I'm aware of Mr. Fauquet's violation of probation, 30-day conviction, while I am aware of the conviction, I am not aware of the details or the specific information regarding the actual violation of probation. With that said, if the violation of probation is for the same exact charges that he's being charged with today, my sanction would remain the same. However, if there's additional information in that violation of probation that could potentially merit a longer sanction, depending on what that information is, if it's not already included in this he's not already being charged for. So I just want to make that clear. So
So
Go
if you would like, I would request a continuance to get a copy of the violation of probation warrant to file it so that we are not back in the same situation where he's being re-violated for the same conduct, if that would be appropriate.
He's absolutely going to be reviolated on the same conduct because it warranted a criminal charge and an entirely separate warrant, which was signed off by a judge and he was found guilty of. Two separate things. And
So
we're
then-
absolutely going to do that.
It's not a criminal charge, it's a civil, it's a preponderance of the evidence standard, so
It's going to be
I
a
would
criminal
disagree with you.
violation.
And he wasn't found guilty, it was an admission.
So with that said, I'm going to take it. So before I take a recess, Attorney Jones, are you going to request a continuance? So I'm
Well,
gonna
if
go-
that's, if what you're,
I didn't charge him with that. Again, I have every right to charge him criminally. I did not charge
So
him
can
with
I
that.
just-
This
okay,
is a
can I just
technical violation.
so for the record, if the addendum included the disposition on.
I didn't
the
do an
violation-
addendum. There's no
Okay.
addendum.
Okay, that's not what I'm saying. I'm saying hypothetically, if the addendum included the disposition on the violation of probation, I believe that the hearing examiner would be considering that. So noting that I requested an addendum to include the violation of probation, which you did not provide, which I understand that you didn't provide it. Okay. I filed it as evidence. So if you can file it as part of the addendum and it can be considered, it should be considered when I file it as part of the evidence as well. That is my
Very
position.
fair, but the new charge and the new violation will include a new warrant as evidence.
All right, so I'm going to take a recess. I'm going to speak to my supervisor about how to proceed moving forward.
Thank you.
Okay.
Yeah, we got my 30 days though. They were sentencing. Yeah, they were sentencing me. Yo, she should prepare me ground. Wait, I would take my 30 days. I got my shit right here. Oh, right. Actually, they
Nicholas, please refrain from speaking right now, okay? Thank you.
Ugh.
Thank you for waiting. We are now back on record. So after, P.O. Bennett, are you there?
Sorry, I'm here.
After consulting with my legal counsel, P.O. Bennett had made it very clear that the state is not going to be filing an addendum for this charge. Therefore, we would not be moving forward with a continuance. And I'm going to make my sanctioning at this time. I recommend revoke and reparole on April 14th, 2025, which is an approximate 8-month sanction with the following conditions. No consumption of alcohol, anger management, no contact with co-defendants Matthew Markham, Jonathan Ortiz, and Laura McDonald, halfway house placement and mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 2nd, 2025. So on that day, January 2nd, 2025, the board is going to take a look at your case, and they're going to they can lessen my sanction, let my sanction stand, or they can impose a sanction longer than what I have recommended. And if they choose to do a sanction longer than what I have recommended, then a supplemental hearing will be held at that time, and they will provide you with written decision as to why they would want to justify additional confinement. Okay, any questions?
I have a comment. Just during the recess, I was able to take a look at the violation of probation warrant, and the conduct alleged in the violation of probation warrant is the same exact conduct alleged here. It's charge 1, as well as the fact that the violation of the parole conditions in general, just so that's clear for the record.
Thank you. So this does conclude the revocation hearing.
Thank you.
Thank you.
Nicholas, if you have any questions, you can give me a call, okay?
Yeah. Fucking equal. You bitches. No.